Hi, this is David Kapalo here. Today I wish to talk about the Rent Act, Chapter 206 of the Laws of Zambia, particularly sections 14 and 15 of this very particular piece of law, which is actually from the Republic of Zambia, where I hail from. I feel or I think that massive awareness hasn't been done in terms of sensitizing members of the public, both landlords and the tenants, as it were. Many people actually are not aware about their rights, whether tenants or landlords, regards what is contained in this very particular law. So therefore, today I thought I should do be one of the solution in terms of disseminating information to this particular piece of law. And particularly today, I'm talking about the section 14 and 15 of this very particular law. And it's actually an old piece of legislation that has been on our statutes or in our statutes in the Republic of Zambia. And I feel landlords and tenants are not actually utilizing or practically utilizing this particular piece of law in terms of their rights and the privileges that are contained in this particular law. So today I wish to talk about the two sections, 14 and 15. Section 15 reads, and I quote it, it says, no distress for the recovery of rent in respect of any premises shall be levied except with the leave of the court. Now, what this particular section is talking about is actually talking about landlords that are in the habit of grabbing tenants' properties in the event that a tenant defaults in paying rentals. Yeah, as it were, there is nothing wrong with a landlord trying to recover the rents that are actually due. But what is supposed to happen is that a landlord is entitled to actually recover the rents that are due, but on the condition that this particular landlord follows the due process, and that due process is supposed to be through the leave of the court, meaning that the landlord in question is supposed to apply to the court, in this case the subordinate courts. You go to the subordinate courts as the landlord. If you feel your tenant has been persistently delaying in paying your rentals, you go and obtain a leave of the court. Failure to follow that due process, then it means that you as a landlord, you are doing what? You are in conflict with the law. And therefore, I felt that this particular piece of law must be made known by members of the public, particularly landlords and the tenants themselves, so that mistakes are avoided here and there. That is on the first point. Then the second point is talking about Section 15. Section 15 basically is talking about restriction on the charging premiums. In other words, charging premiums. So this restriction on charging of premiums is basically talking about security deposits. So many landlords out there are in the habits of, especially for residential properties. For residential properties, the law is very clear. Section 15 is expressly prohibits the charging of security deposits. And this is why today I felt I should talk about it, because this practice is actually widespread out there. Some landlords are doing it knowingly, others are doing it unknowingly, and mainly the majority are the ones who are actually applying or not applying this law. In other words, they are applying this law unknowingly by putting provisions in the tenants agreement that talks about paying of security deposits. But when in actual sense, the law as it is currently now prohibits charging of security deposits, or as it is framed in the law, restriction on premiums or charging premiums, which is basically security deposits. So out there, if you are a tenant, if you are a landlord out there, and you are in the habit as it is now of charging security deposits, as it is, security deposit being incorporated in a tenants agreement is actually unlawful. And if a tenant, should there be a dispute and the matter finds itself in the court, the particular landlord in case might be cited for a criminal offense. Actually, Section 15, subsection 2 actually criminalizes the charging of security deposit. And allow me to read it. Section 15, subsection 2 says, any person who requires or takes any payment or consideration in contravention of this section shall be guilty of an offense and liable on conviction to a fine not exceeding 4,000 penalty units or to imprisonment for a term not exceeding 12 months or to both. So 4,000 penalty units, you can find the figure there. You divide it by 4,000 penalty units times 0.30 ngwe. 0.30 ngwe. The figure that you find is the amount that you'll be charged should the court find you guilty. Or you can be sentenced both ways. Either you pay a fine of 4,000 penalty units or to imprisonment of 12 months or to both. And this is the reason why I'm saying this has to be made aware to members of the public, the tenants themselves as well as landlords themselves. So as it is now, there's the Law Development Commission is actually carrying out a review of this very particular law, and this Law Development Commission of Zambia actually started a long time ago engaging stakeholders on how best to proceed with these reviews. And for landlords that feel the law is actually unfair, which I agree with actually most landlords, because there are some tenants who are in the habit of destroying landlords' properties and leaving it damaged like that. Some of them even disappear without even informing their tenants, and hence the need for them to be charging these, or the justification for landlords to be charging security deposits. But as it is now, the law prohibits charging security deposits, and it is in this vein that maybe the Zambia Law Development Commission has embarked on a review of the law, which is the Rent Act, Chapter 206 of the Laws of Zambia, and Chapter 193, which is the Landlord and Tenant Business Premises Act, which is being reviewed. As we are speaking right now, the Law Development Commission will be in Livingston, I think, on Thursday, the 24th of April, in the Livingston City. They'll be conducting stakeholder engagement. So for landlords that feel that the law is quite unfair on their part, this is your chance for you to go and make your submissions in Livingston for those that are Livingston residents. So please mark that date, attend those stakeholder engagement sessions that will be held by the Law Development Commission in Livingston City, and then the venue will be announced maybe as we go on. As I continue sharing a series of these updates with you on our Facebook page, I'll be able to tell you the venue where this will be held. But for now, please be aware, be informed. If you're a landlord or a tenant right now, charging of security deposit is an offense. And for those other property owners or landlords who are in the habit of also levying, where if somebody, because has delayed in paying their rentals, you go and grab their properties, that is also unlawful unless you do it through the court. But should you have any questions, please remember to drop your questions or comments in the comments in the comment section below, and I'll be able to attend to them. For now, I thank you so much for taking your time to watch this video. And then if you have any other questions or concerns, please don't hesitate to get back to me through the comment section. Thank you so much for your attention and for watching.